I'm David DeGroot. I'm the president of the local chapter of the Federalist Society. Welcome. We've got a great event tonight on the Microsoft consent decree. Rick Rule told me a few moments ago that it's only been in effect for 8.5 years, but what's a year and a half between friends, right? But it does, the Microsoft case does represent an important juncture in the history of antitrust law in our country, maybe no less than the IBM and AT&T cases of the 1980s. Both because of the position that Microsoft had at the time the consent decree was entered 10 or so years ago, and also because of the developments in the computer industry since then. I'm certain that many people will give credit to antitrust enforcement for some of those developments, and other folks will find that the contribution of antitrust enforcement to the evolution of the computer industry to be less than important. Either way, we're here to discuss that and other things. I've been instructed by our panelists to give brief introductions, and I will try to honor their requests. So immediately to my left is Judge Douglas Ginsburg of the DC Circuit. He was one of the panelists on the appellate court that reversed the trial court's ruling, or motion. You can discuss what you did and didn't do to the trial court's ruling. US v. Microsoft. But in any event, Judge Ginsburg's been very intimately involved in the proceedings over the years, and he's going to give us some insight into those. He was appointed to the DC Circuit by President Reagan in 1986. Before that, he was a professor at Harvard. Earlier in his life, he went to Cornell University, where he roomed with Ken Dryden and was on the JV when Cornell went 29-0 and won the NCAA championships in hockey.
Important stuff. Did you realize that?
Never clue. Some of the information you'll be hearing tonight is true, but you're free to choose what is and isn't true about that. Rick Rule is a partner at Cadwalader. Did I get that right? Wickersham and Taft in Washington. Rick has been in private practice for quite a while, but he began, or early in his career, he worked with the antitrust division, who was with William Baxter, who was, and I think you must have been involved during that time in both the AT&T and IBM cases in the mid-'80s. Rick was also involved in US versus Microsoft as counsel for Microsoft in that matter. And Phil Malone on the far left over here which is not in this instance a dirty term for you Federalists.
I'll do my best to uphold that placement.
No, we always have to have someone on the left, so you're the person who's got that job today, Phil. Phil is at the Berkman Center for Internet and Society. He's the director of the Cyber Law Clinic at Harvard Law School, and he worked with the Department of Justice on behalf of the Antitrust Division in the US versus Microsoft case. So they're going to give you enlightenment, and I'm going to sit down. Thank you very much, Judge Ginsburg.
Thank you, David. Thank you, David. Thank you all for being here, and especially our other two panelists who came across the country just for this purpose and are not spending nearly enough time in San Francisco relative to the time on the airplanes. In fact, I think it's about a draw for you. Pardon me. One of the great pleasures or satisfactions of being a judge, and maybe especially a federal judge, is that there's this constant stream of interesting issues being presented to us. Just about every case that reaches the Court of Appeals is one that's worth hearing and worth thinking about and working on, and that makes it very rewarding. One of the frustrations of the same situation is that having gotten to learn what we need to know about a particular field and a particular aspect of the real world, it quickly goes away, and we never see it again. We on the Court of Appeals learned a great deal about things like APIs, but I had to be reminded earlier today what it stood for. Our involvement is, in other words, if it's at all deep, it's brief, but deep down, really, it's shallow. We get to then see the aftermath of the case as it's reported in the press, if it is reported in the press, but not much more. So 10 years have elapsed since the circuit decided the Microsoft case, and I have become as ignorant as anyone could be about the sequelae. But fortunately, we have experts with us who can fill us in on what's happened in the intervening 10 years. As you may know, what's going to happen this week is the expiration of the decree within the next couple of days, actually. Now, the Code of Conduct for federal judges prohibits me from telling you anything interesting, which is to say anything that isn't about the case, which isn't public record. So I'm going to choose my words carefully as I address the question which is on everyone's mind 10 years after the fact, which is, why did the court hear this case en banc from the outset? Or as we say in Latin, en banc ab initio. And there were 7 judges on the court who were not recused. Those unfortunate 7 were out of a bench of, I believe, 11 at the time. And under the rules then in effect, a petition for rehearing en banc of a panel decision required a majority not of just of the judges active and voting, but of the judges of the court, all the active judges of the court. So a recusal counted effectively as a no vote if it came to rehearing. And the configuration of the court, the number of judges on the court and the recusals was such that if this panel, the panel that heard Microsoft, I should say a 3-judge panel, made a decision that was then the subject of a petition for rehearing, there would not be enough judges who were not on the panel to vote to rehear it, and the panel would effectively be final. Now, that was my personal reason for thinking that we should hear this from en banc from the outset. Others had other reasons. The most obvious of one was that it was an important case that struck me as the least good criterion for deciding whether to hear something en banc from the outset. The only other time we had done it was in the Nixon tapes case, when I was actually clerking for one of the judges on the court. And it hasn't been done since. So it was done by 7 judges. The opinion issued per curiam. There is no one in a position to claim authorship, and we can all secretly repudiate the parts we don't agree with. We've been asked by the Federalist Society to address in particular, what was the effect of the decision for the company, for the industry, for the path of development in the related fields, and the significance, if any, of the case for continuing as a continuing matter for antitrust doctrine. Rick Rule and Phil Malone negotiated this decree on behalf of their respective parties. So we are in an extraordinarily privileged position to get some of their recollections on the negotiation of the decree. And how did we decide we would start? Phil, you would lead that off. Plaintiff goes first on this.
Right, perfect.
Okay.
So thank you for the introduction. Thank you for the invitation here. Let me just say, so we're going to talk mostly about the decree and its impact tonight, but I think we're also going to be talking about the case more broadly as a whole. And so I want to first just to sort of set the scene and try to put it in context, especially for those of you who were probably not even in grade school maybe when the case happened. I teach this case now in my antitrust and technology class, and it's shocking to realize that for most law students, they were 7 or 8 years old when the case first started. So it's been that long. So I want to try to do the impossible and give you a whirlwind tour of the case, start to finish, in less than 3 minutes. Before I do that, let me just say, Rick and I really, there's a lot of overlap, but we really cover the entirety of at least this part of the case, from start of the investigation that led to this case all the way through the end of the consent decree. I was there in the early part. We overlapped during the settlement, the negotiations, some of the compliance. Then I got away, finally, thank goodness. And poor Rick has been stuck ever since in enforcement, compliance, Europe, and a lot of other pieces. But between us, we really cover the whole waterfront. And Judge Ginsburg was there several times nicely right in the middle, having to deal with what it was that we were doing. So here we go. 3 minutes or less. Let me try to give you the grand tour of the case. We'll see if I can actually do this. So it begins, shockingly, 1990. 21 years ago, the FTC begins investigating Microsoft for possible violations of the antitrust laws through its licenses for computer operating systems. 3 years, the FTC did that. 3 years later, the commission tries to do something, but they're deadlocked, 2-2. They have one commissioner who recuses, deadlocked 2-2. A very unusual thing happens. DOJ takes over the case from the FTC. Almost never happens. DOJ investigates. 1 year later, in 1994, the DOJ files a complaint against Microsoft alleging violations for licensing. At the same time, they file a consent decree, which is similar to one filed by the Europeans, that restricts Microsoft's licensing practices and has a provision that says essentially you can't tie, very much a sort of tying kind of provision. So that was entered in 1995. Now, after that, while this was going on, this internet thing started to catch on, right? The World Wide Web actually started to turn into something, and people began to come up with this thing called the browser. Mark Andreessen and his colleagues developed something and started a company which probably many of you don't remember or maybe never heard of, called Netscape. Netscape had a browser. There were allegations Microsoft was doing some anti-competitive things to try to keep that browser from succeeding in order to protect Microsoft's monopoly. So in July 1996, not very far up Market Street from here at 450 Golden Gate Avenue in the Federal Building, the complaint about this landed on my desk. And so a team of lawyers here in the San Francisco office of the Antitrust Division and I began investigating. In late 1997, we filed a contempt action against Microsoft, alleging that they were violating parts of the consent decree. In December of 1997, Judge Jackson in D.C. agreed and issued a preliminary injunction telling them to stop doing certain things. They appealed very quickly in early 1998. A panel of the D.C. Circuit, not including Judge Ginsburg in this case, in a case that's called Microsoft 2, and you'll see in a minute why the numbering, said not so fast. We're very skeptical of the government intruding on product design, and you didn't really do proper procedure, so we're not going to do the preliminary injunction. Soon after that, May 18th, 98, the government filed its antitrust case against Microsoft, went to trial from August to about April of 99 before Judge Jackson. Some of these folks, David Boies, John Warden for Microsoft, and others argued the case. On November 5th, 1999, Judge Jackson issued his findings of fact, which are quite harsh toward Microsoft and essentially upheld most of the government's case. He then sent the case into mediation before Judge Posner. Not the most successful thing. I spent a lot of time in Chicago. It was fascinating and completely unhelpful. On April 1st, April Fool's Day of 2000, it fell apart. 2 days later, on April 3rd, Judge Jackson issued his conclusions of law, which also adopted the government's remedy, which said break up Microsoft into two companies. Microsoft appealed. And on June 28, 2001, the D.C. Circuit, in the decision Judge Ginsburg was just talking about, issued its Microsoft 3 decision, upholding some parts of the liability case, reversing some, remanding part of the case, and throwing out the remedy for various reasons, and appointing a new judge because Judge Jackson had been a bit chatty with the press while the case was still pending. Not good. We then had more negotiations and more mediation. This is where Rick and I sort of merge our paths. Spent a lot of time together doing that. In November 2001, the Justice Department and 9 of our state co-plaintiffs out of 19, I believe, agreed to settle the case. I went through a Tunney process, 32,000 comments that the DOJ had to respond to. You didn't have to do any of this, lucky you. The other states decided, nope, we want more remedy. They had their own trial before Judge Kohler-Catelli in 2002, try to convince her more remedies were needed. In November 2002, she mostly rejected that and upheld our settlement, which is the final judgment we're talking about here today. One state, Massachusetts, appealed that decision. On June 30th, 2004, we get Microsoft 4 from the D.C. Circuit upholding the final judgment we're talking about, rejecting the Massachusetts argument that more needed to be done. On November 12th, 2007, the decree was supposed to expire. It didn't. There were a couple of extensions and things dragged out. It's now going to expire tomorrow, which is why we're here to talk about it. So that's the history. It took 4 minutes and 50 seconds. I'm sorry, I'm not as fast as I used to be. I may have left out a few details along the way there, but hopefully we'll get back to those. So let me just say this about the final judgment as introduction, and then I want to sort of move on to us actually talking about it. So as I alluded to here, the DOJ began the remedy process with Judge Jackson seeking a breakup of Microsoft, a structural remedy that would essentially separate it into 2 companies in a very complicated way. The final judgment that was entered and upheld by the D.C. Circuit was far more modest. It was a decree that was conduct restrictions only, no structural relief. And the restrictions primarily banned the kind of practices that had been involved in the case, basically said, stop doing this, let's prevent the recurrence of this, and in some way, let's try to recreate the competitive conditions that might have existed. Very, very different. Why the change? Well, there are at least 2 reasons. One, the D.C. Circuit decision, Microsoft 3, cut back on liability findings to some extent. That made pushing for a more extensive remedy a lot more difficult, and there are plenty of statements in the Microsoft 3 decision that while they stopped short of saying we're resolving the remedy, they said we're sending it back, but they sent a very clear signal that a structural remedy was going to be scrutinized closely and would require a great deal of specific tying to maintenance of monopoly. And that was going to be a tall order. There had also been a change of administrations. So Joel Klein, who had been the Assistant Attorney General during the trial and the initial proceeding, was replaced by Charles James. And there was a very different view of what sort of remedy was appropriate, both in this case to try to fix the problem and more in general, what the proper role of antitrust was. The final judgment, the remedy was hugely controversial. I think 32,000 comments in the Tunney process gives you some sense of that. If we had more time, I would read to you some of the greatest hits from there, but they included things like, and we got attacked viciously from both sides, which is always a good sign, I suppose. There were those who thought that we were, interfering in the market and likely to kill the goose that had laid the golden technology egg. There were other people who thought that this was a complete sellout and a political disaster. One of the comments I remember was something along the lines of, I hope you're all taking plenty of Dramamine to deal with the seasickness that must come from rolling over so quickly. Lots of things like that. Hugely.
Is that from the governor of Massachusetts?
I can't remember who. So I think Rick is probably in a similar position. I'm not still, even though I've been gone from the Justice Department, I'm not at liberty to go into all of the details of who said what and how things were decided and what the internal infighting was. Suffice it to say that a lot of people on the government staff side were not happy with the remedy we settled with. I personally was disappointed, to say the least. But I also felt that it was met at least the minimum threshold of what was in the public interest, because I signed pleadings to the court saying this is in the public interest. And I believed that, but it was far short of what, in my ideal world, I would have liked to have seen. So I'm going to leave it there. We can talk about specific parts of it. Let me just say, for the remedy itself, the final judgment that we're here to celebrate the end of, the effect of, whatever we want to call it, most of it dealt specifically with practices that had been part of the case that Microsoft had been found to be doing to exclude competition and to harm competition. There was one very forward-looking piece of the remedy that went beyond, and in fact wasn't specifically related to conduct in the case. That was what we called Section 3E, or the requirement that Microsoft license the communications protocols that the Windows desktop operating system used to communicate with Microsoft servers. The idea being that in order for other server competitors of Microsoft to be able to really compete, they needed access, because Microsoft's desktop was a monopoly, they needed access to those same communications protocols. And the theory, certainly very much based on the big picture of the case, was competition was likely to come not from another desktop OS, but from what we now call the cloud, from things out there. And if other server manufacturers could also be excluded because Microsoft had this secret sauce built into the operating system, that would hurt competition. As Rick, I know, will talk a lot, that provision ended up occupying much, maybe most of the time of the enforcement and compliance. And there's some interesting discussion to be had about whether that very forward-looking, fairly radical provision made much or any difference in the end.
Phil, would you just, pardon me, just
Yeah.
describe briefly what the divestiture remedy was that the Court of Appeals, of course, as you said, remanded for reconsideration.
Right, with some fair skepticism. So it's, and I apologize, I've forgotten the precise details. It essentially would separate Microsoft into two companies. One, an operating system company, which had the current version, the most current version of the operating system, and access to the Internet Explorer code as it existed at that time. The other one was going to be an applications company, Word and other applications, but it would have access to the older version, the sort of older family of the operating system. The idea being that we wanted to create some incentive for there to be competition between the two, and if it was a pure operating system company and a pure applications company, maybe you wouldn't have that. If one of them had an operating system that it might develop to potentially compete, then you might get somewhere. And if you split it into baby bills, as everyone liked to call it, 3 operating system companies, that would essentially do nothing. They would probably quickly tip to whichever one of those companies had Bill Gates as at the head.
Thanks, Phil. Rick?
Let me try to pick up the story, although I think, we could all go home now. Phil's given us a pretty complete and thorough analysis of what happened in the case. But I actually was sort of in the background, even beginning in the early 90s, and got involved with the case, actually, because I was retained by Microsoft, not to be part of the trial team initially, but to help explain what was going on to the press, which was in and of itself kind of an interesting assignment. But I did get involved actually in Phil's description when Judge Jackson ordered the mediation by Judge Posner. I had been a law student at the University of Chicago Law School and had worked with Judge Posner, who was then just a professor. No offense. And one of the interesting insights that I got through the process was how different the mediation was in 1999 versus the mediation that ultimately led to the settlement. I've always felt that part of the reason the one in '99 didn't work is Judge Posner had this approach, and the team from Microsoft, and there were about 4 of us who were the core team, and then we would add people. We went each of us went the same week, right? But we went one part of the week, and you guys went the other part of the week.
Yep.
And so we'd sit there and spend the day talking to Judge Posner, but he never really put the two sides together. And I always felt that we might have been able to make a little more progress, and had there been a little more involvement, because I do, and it turned out that in 2001, when we did that mediation, it was really face-to-face, and I think it turned out to be more effective. The other thing that's worthy of note The mediation that occurred in 2001, it's true it was after the Court of Appeals decision, but it also was based on an order by Judge Catelli, who was the judge to whom the case had been assigned when it was remanded, who, by the way, is, I will say, and it may be, I don't think it's Stockholm Syndrome, but I think she's acquitted herself extremely well in the case. And after 9/11, she basically said, look, this is kind of crazy. Why don't you guys go out and see if you can settle this. If you can't settle it, then I want to appoint a mediator. We spent a couple of weeks negotiating a settlement, and we actually made some progress. And then Eric Green came in and brought us to the finish line. And I also think that just as this decree will have an impact in future cases, to some extent, what happened in that negotiation and the way that decree evolved, at least from my perspective, but I think this maybe is because of my background, but was a reflection of some of the lessons that had been learned in the AT&T decree. And one of them, and I remember spending a lot of times talking about this, was the difficulty that the antitrust division had in the AT&T decree in terms of keeping up with the technology, and feeling to some extent at a disadvantage with respect to the parties in a complex technological decree like that. And at least it was my sense that really throughout the process in trying to resolve it, there was a concern on the part of the Department of Justice that they too might be put in that position. And one of there are various features of the decree that I think were designed to address that. And I believe if you were to ask the folks who were there at the very end of the decree, I think that part they felt worked out pretty well. One of the interesting differences between the decree that was negotiated and the decree that the states got, really the principal difference was that in the decree that was negotiated there was something called the Technical Committee, which was in part designed to deal with this technological asymmetry, if you will, between the department and Microsoft. That was part of the theory. There are three members of it, one appointed by the defendants, one appointed by the plaintiffs, and then they would appoint, in effect, a chair. That committee essentially looked at a lot of the technological issues. What we call the litigating states, which essentially ended up being the California plaintiffs, notwithstanding that Massachusetts was one that held out. One of the points that they fought was the Technical Committee. I'm not entirely sure why, but they fought it. And so one of the things the judge did in their decree is they were not the beneficiaries or subject to the Technical Committee. Though if you look at the transcripts of the hearings later on, you will find that one of the biggest supporters of the Technical Committee at the end of the day was California and the California plaintiffs. I'll leave it to others to judge the effectiveness of it, and it certainly became a bureaucracy unto its own. Very large, and it was reasonably expensive. But I think from the judge's point of view, at least as she articulated it from the bench, she found the Technical Committee at the end of the day to be very effective. I think it gained a lot of credibility in her eyes, and I think gave her a lot of comfort that she didn't have to worry a whole lot about that technological asymmetry that maybe had been a bigger concern if you go back to other decrees. But once the decree was entered and we lost Phil, I must admit that it's one of the things, I don't think it is Stockholm Syndrome, but you end up in a context like that, I think, developing a lot of professional respect for the people that you had to deal with on the other side. Phil, I think, it was clear to us that maybe the staff wasn't entirely happy with what was being negotiated, although I think it was a very fair outcome. But they always conducted themselves very professionally and did so throughout. The interesting thing to me, looking back on it, was I would not have predicted in November of 2001 or later in November of 2002 that 3E would have become as important as it did. There were a lot of parts of the decree. They, as Phil said, some of them required Microsoft to access Windows only through APIs with its applications and other things through APIs that it published and allowed other people to use. Part of it essentially affected the design of Windows and how Windows had to be designed with respect to middleware products. And there was a provision that one thinks that perhaps some on the government side held their nose a little bit when it was signed, that essentially required Microsoft to charge the same price to all OEMs. But all of those provisions, I mean, from time to time there were issues that had to be dealt with by Microsoft and the parties. But none of them, interestingly, none of them rose to the level of a complaint that was presented to the court. So you could think of, and the judge will remember when we were in the department with the AT&T decree, we heard a lot, and there were a lot of issues that found their way back to Judge Green. But it is kind of interesting that here, at least leaving 3E aside, the decree worked pretty well in the sense that there were no complaints that ever arose that couldn't be worked out between the parties that ever had to go to the judge. 3E was a little different. 3E, I think perhaps because folks didn't understand the significance of it, took on a little bit of a life of its own. And the question early on, it was never really a question of licensing the protocols, although early in the decree a lot of time was spent in terms of developing the mechanisms for licensing the protocols, and there was a lot of time spent between Microsoft and the plaintiffs in developing the licensing agreements and the licensing protocols and the amounts of money that could be charged. But what really became significant was, okay, great, you're going to license the protocols, but what does that mean? What are the protocols? Because unlike APIs, which are the application programming interfaces that you write your software to interact with the operating system, protocols are what is the language of communication across a wire. And Microsoft, before the decree was entered, didn't document those. It was, different engineers would put the protocols in the operating system, would use it in the server, but it wasn't necessarily documented, it wasn't made available. So part of what had to happen in the decree was to come up with a way of writing those protocols, and the standard that they had to be written to became a big issue. And the reason that the decree got extended, for example, originally the decree was scheduled to last only 5 years. It got extended originally voluntarily by Microsoft because essentially folks stepped back and looked at the communications protocol documentation and felt that it really had not been done as well as it could have. Microsoft agreed to rewrite the protocols, the documentation. And on that basis, essentially, the decree was extended for a period of time. The government had a right unilaterally to extend it, which it did because some of the process was still going on. But it was only extended once. It could have been extended for 3 years. They extended it for a year and a half. And the other parts of the decree also got extended because the states asked for that for the judge and said that, look, the whole decree needs to be in effect until these protocols are implemented. So that process really took most of the time. That was the focus of the technical committee. The technical committee, by the time it ended, had a very large staff of most of them reside down here. Some of them were up in Redmond. But they essentially, the project worked. I think that There's general view among the technical committee that the standards that developed for writing protocols were as good as any standards for documentation that exist. They're very high quality. The other thing, and then we can move on, I think it's important to see the decree in many ways as a success in the following sense. I think its provisions worked because, as I say, there weren't a lot of things that went up to the judge. We did go to see the judge 4 times a year, but there weren't complaints. But it was really a success in the sense that I think it was a transformative event for Microsoft. And the company recognized as a result of that to some extent what was being called for was not inappropriate and was not inconsistent with doing business. So the folks who, and we might have been among them at the time, who thought, wow, this is going to be the end of the company, were not right. I mean, there was a way to live with the decree in a manner. It was costly. So anybody who thinks it was easy for the company and cheap, it wasn't. It cost millions a year. But it did affect the companies going forward. The company issued Windows principles that essentially say that they're going to live by the same principles going forward even after the decree. They'll evolve, obviously, with the technology. And then they also agreed to interoperability principles that essentially involve continuing to document interfaces for their really significant commercial products. And that kind of got embedded into the company. And it's a very different company, I think, today than the company that it was a few years ago. I don't believe that it's lost its ability to innovate. I also don't think, although there are more lawyers today at Microsoft than there were 10 years ago, but I don't think they suffer from the problem that IBM was reputed to have suffered from, which is that no decision could be made without lawyers going over everything, and there was this lament that IBM was run by the lawyers. Microsoft is very careful. It wants to make sure that it follows the law, which I think it does, but I don't think it's run by the lawyers. It's run by the people who are engineers. So to some extent, the lesson is you can affect the behavior of a company for the better, and you can do it without necessarily having to break the company up. So it was a success in that sense.
Rick, one of my law clerks who came from Chicago after getting a JD and MBA had spent a summer working at Microsoft, and he was struck by the pattern of the practice of the company, calling for a lawyer to be present at all sorts of meetings. I mean, just things that he thought were pretty benign, but people were very conservative about having a lawyer there. And I think maybe the idea is have the lawyer at the outset rather than at the back end, so you don't have problems.
I think that's right. And again, it really is not the case that lawyers are making the decision at the company, and I don't think they ought to be. And that was one of the concerns. But it also makes sense to make sure that as decisions are made, there is sufficient legal input so folks understand, certainly at the time of the decree, but even afterwards, what the obligations of the company are.
Phil, were you at the department during the AT&T administration of the MFJ?
During some of the administration, yeah, I came soon after the breakup, but then I was there to witness firsthand some of that, and just the numbers of people who spent huge amounts of time worrying about it, meeting with Judge Green.
For those for whom the AT&T experience was prior to your being aware of these sorts of issues, the department was unwillingly cast into the role of a mini regulator, really, acting as a sort of staff for Judge Green when proposals came forward from any of the Bell operating companies to diversify into some new business, and they needed a waiver under the decree. So the AT&T staff at the department was busy analyzing whether there would be a competitive fallout from particular companies entering into a new line of business, and it was a very unwelcome role for the division staff. who had always thought of themselves as, with some justification, as not as regulators, that antitrust was distinct from regulation. I think Rick and I tried to disabuse the staff of that when we were there, but we certainly didn't embrace the idea of being staff for Judge Green and being a little mini FCC. And it's interesting to me that experience may have shaped your thinking on both sides going into this decree. If you've seen Bob Mnookin's new book, Bargaining with the Devil,
yes,
he describes something like the technical committee being set up here to resolve a dispute between IBM and, was it Hitachi? It came out of an intellectual property dispute. No one really wanted to have it in open court. And so they set up a mediation with a panel, just as you described, and a third independent. And that panel ended up setting up a bureaucracy that administered the decree for some years, or the agreement, the settlement for some years, because it was technical. I mean, that may be another thing that's come out of this as an available model for future resolutions.
And I would certainly, I guess, third the praise for the technical committee. I think it was an idea that everyone was uncertain about early on, and certainly people within the government side worried about how it would work. We worried about the system for constituting it, given that DOJ and the states would nominate one person, Microsoft would nominate one person. I think we all just assumed that Microsoft would nominate someone who was hell-bent on undermining everything. And it turned out that all three of the members, both the one we appointed, the one Microsoft appointed, and the third one that they chose, were absolutely dedicated to doing the right thing. And they really got it. And I think they were having someone that Microsoft had chosen on the team led to much greater, I think, buy-in and just credibility within the company. And it really did turn out. Again, we can debate how much the thing that they spent most of their time on, 3E, the communications protocol, how much that made the competitive world a better place. But as a matter of making that provision do what it was supposed to do, at least operate the way it was supposed to, and avoid these kind of awful Judge Green regulatory issues, I think it was incredibly successful.
Phil, as you look back at it as policy, I mean, you weren't as happy with the decree as you were with your original. But was your preference for the original relief or something still different?
Well, by the time we got to negotiating the decree, I think certainly I had moved on from the idea of a breakup and recognized that for a variety of reasons that was not going to happen, whether it should or not. So my preference was for a more rigorous, more tightly written, perhaps somewhat broader set of conduct restrictions, but still something in the zone of what we ended up with.
And what do you think the effect of it was?
That's the $64 billion question, right? So even it's an interesting position to be in, even with my stated disappointment with the way the decree turned out at the time and my desire to have had something that was stronger, that was broader, that would have done more. I still come out now, 10 years later, thinking that in many ways the decree was a considerable success. It's important to recognize what it didn't do. So it did not inject much meaningful competition into personal computer operating systems. So to the extent that was someone's goal, that we want to actually create competition for Windows, that didn't happen. Microsoft still has a very strong position if you think about operating systems running on desktop and laptop computers. But part of what's so fascinating about the case and what you and the rest of the circuit grappled with, and I think well, is trying to understand in a case like this where there's been proof of anti-competitive conduct, certainly proof of the potential for competition had the browsers and Java been allowed to flourish without interference. But it wasn't ever a case where we could say, here is the but-for world. But for Microsoft's anti-competitive behavior, this would have happened, these other applications would have been developed that would have run cross-platform and that would have, in a reasonable amount of time, begun to undermine the core of Microsoft's dominance on the operating system. There was a very credible theory about how that could have happened. Microsoft itself feared that that was going to happen, and there's certainly a lot of our proof was Microsoft's own documents about the worry over that happening, and that's why they took steps to stop it. But because there was never sort of a solid connection saying, because you did this, you stopped this thing from happening, and there's an 85% chance it would have happened but for that, then it's much harder to think about something like a breakup.
Well,
So
with 10 years of experience under the decree, did anything happen? Where's Linux? Where's Apple?
So, right. So
Shape?
Apple is in better shape than it's ever been. I don't know that much of that has to do with Apple's sort of pure position on the desktop. It's happened through a lot of other great and innovative things that Apple has done. But you know, the world looks pretty different. Microsoft still has a very strong position in operating systems. No question about that. But we now see a world where, you know, many of us do a lot of our computing on devices like this. And, you know, other mobile devices and on iPads. Much of the computing that we do is now out in the cloud. It isn't necessarily on the desktop. We have a non-Microsoft browser, Firefox, that has a certainly credible share. I don't know what the current numbers are, but it's, you know, doing very, very well, way better than Netscape was in the final days. And my personal view, which is impossible to prove, so it's easy to say it, is the provisions in the decree and the process of the case, the process that Rick just described of Microsoft kind of stopping, taking a look at itself and saying, all right, we need to change the way we do things and we need to follow these principles, I think has allowed all of those things to happen in a way that they probably would not have, certainly at a pace that they would not have, but for the decree. And one of the things that I kind of get worked up about, I've seen a lot of articles and things over the last year or two of people saying, you know, you look at what's happening with Apple, you look at the cloud, you look at all this other stuff. This proves that we don't need antitrust enforcement. The market took care of everything. You know, we told you the market would come along and there would be all these changes and Microsoft's position would be undermined. And now look, you know, Google and Facebook and other companies that didn't even exist when the case was going on are now major threats to Microsoft. You know, I think there's some truth to that. And again, they have not undone Microsoft's position on the desktop. You need to be clear about that. And that's still incredibly important for consumers. I mean, still, you know, tens of millions of people, maybe more, in businesses that have to have Windows. But even the other great things that have happened, you know, I just don't think we would have seen them at the same pace, in the same way, in the same richness, had the breathing room that the decree created not existed. Can't prove that, but I think that's the truth.
I mean, the only thing, I agree with Phil. Nobody's ever going to be able to prove it one way or the other. I think that it's probably, I think it is fair to say that that the decree was helpful to a company like Firefox. I don't think there's any doubt about that. And essentially, it's hard to know what wouldn't have happened had the decree not been there, had Microsoft not, you know, transformed the way it did. I do think, though, that and one of the reasons the decree is ending, even a little later than it was intended, in less than a decade, is because it was understood at the time that there would be a lot of these changes. And again, you know, who knows whether it would have been the same thing, but I think Phil is right. If you look at the way people interact today they compute and they interact with the web and they interact with clouds, you know, the form factor really has kind of shifted from the PC, which is fairly ubiquitous today, to tablets, to mobile platforms. And I don't think it's because of the decree, but, you know, if you look in those areas, Microsoft is generally sort of right now at least running third or fourth, depending on which form factor you look at. I think the whole paradigm in many ways has changed. If you know, when we were negotiating the decree, I think we knew what Google was, probably. But
we certainly knew there was such a thing. I don't think we knew what it was. We certainly didn't know what it was going to be. But yeah.
But you know, I mean, certainly one can make an argument that because of the way things develop, they have become extremely important in that whole process in terms of directing traffic and winnowing through information, and they've developed a really important position at the very least. But I, and I will say that Google availed itself on many opportunities, both in the United States and in Europe, the antitrust process to help it out. And I assume it did so because it thought it could get help from that, as opposed to just trying to put sand in Microsoft's saddlebags. But at any rate, they definitely availed themselves of the process, although it's hard to see directly how the decree really affected that business very much. But it's just a very different world, and I do think that when we sat down to negotiate in 2001, we weren't really in the business of trying to predict where things would be in 2007 or in 2011. I think, though, we did realize that even if we had tried, we never would have guessed what the world looked like. And that's one of the reasons that it makes sense for decrees to end. And I think the judge recognized that it's kind of done its job. It has transformed the company, but the economy has moved on. The decree probably played some role in that, but whether or not the decree had been there, a lot of these changes I think would have taken place anyway. So.
Rick, do you think the positions staked out by the by DG Comp, by the European Union, since the decree, mean that in their view it's inadequate? They've sought more relief.
I would have to defer to the department on that one, in terms of whether or not that's what the commission was communicating to them. I think the commission's position, as articulated, was that they had their own concerns, and that they were going to deal with them, and whether or not the department saw things the same way. There's been a lot of interaction between the EU, the EC, and the department. And from what I can tell, the relationships are probably better than between the DOJ and the FTC. So,
not that that's a terribly high standard these days.
But at any rate, they have gotten along. I mean, it is true, and everybody should be aware of this. Notwithstanding that the U.S. decree is ending, Microsoft's undertakings with respect to Europe go on for some period of time. 3E, interestingly, was a concept, that is protocol communications, was actually a focus of one of the EU's investigations at the time the decree was negotiated. And after that, the EU's concerns sort of morphed. Originally, it had been client-server communications, and it kind of morphed into server-to-server communications, or at least for server workstations or work groups. So to some extent, there's been a reaction. Probably, I think you can say, again, stepping back and not looking at the particulars of Microsoft, one thing that Microsoft did force the department and the EC to do is to interact. And I think that over time, the relationship and the way of working through issues has evolved over time, and probably for other businesses in a somewhat better way. I do think that today there's probably less friction than there was in 2001. Now, again, I don't think that's just due to the Microsoft case. And if you'll remember, between those two time points, you have the GE Honeywell case, which was
a low point.
Yes, a low point. So things have changed there, but Microsoft created was part of the catalyst, I think, for trying to work through those issues. I think it also probably played a role in there's much more sort of international interaction than there was before. So I think Microsoft has served as a basis for cooperation beyond what it was in 2000, for example.
Phil, the Europeans' view on the media player seems like a replay of to some extent, of the browser issue here with integration.
Right.
Is that fair?
Well, it is with a plus, and I think to me that's always been one of the fascinating, if you're really trying to take apart our decree and what they did and decide what's necessary for competition, it's a great comparison. So what the U.S. decree did basically was say that to Microsoft, you can't prohibit OEMs from adding whatever software they want of certain types, putting on icons and means of access, and you have to allow OEMs and end users to remove your middleware products, your browser, your other things. But removal was essentially removing the means of access, the icons, menu entries, and so on. And Microsoft, under the decree, created this utility called a set programs and defaults utility, which would allow users to then say, all right, I want the Microsoft suite of things, I want the independent suite, I want a custom mix and match. And the theory behind that solution was that what matters for users in terms of whether a program is there or not is all the means of accessing it, not the plumbing, not the code that's underneath. The states that didn't settle had a different view. They tried very hard to persuade Judge Kohler-Catelli that code removal needed to be part of it, and Microsoft had to actually go in and take out some of the plumbing. She rejected that.
Brought that up on appeal.
Right. D.C. Circuit very soundly rejected that. But the Europeans decided that was important. Their theory, which is certainly plausible, I mean, you can debate what you think, and I think in the case of Media Player, I can't agree with them, but the theory was that, it's great from the consumer standpoint to say, okay, I want to make this go away. Or if you're an OEM, you can say, I want to ship a machine that doesn't appear to have two browsers on it. So there's no Internet Explorer, there's just whatever I put on, there's just Firefox, or there's not several different media players. But they saw a problem for competition if all of the underlying functionality was still there, so that other people who were writing any kind of audio programs could simply say, aha, we know that on every single copy of Windows shipped, there's going to be all this underlying media plumbing, and so we're going to write our whatever kind of application or whatever thing we do to call on that and invoke it. And as a result, Microsoft's Windows Media format has a huge advantage and becomes ubiquitous. And it's not something anyone else can ever duplicate. Now, what they saw as an unfair competitive advantage, Microsoft and a lot of others saw as really efficient for consumers. That we're building in the plumbing so that other people writing applications can take advantage of it.
No, when they offered a European version without what was it, the browser or the media player?
Media player,
Without
right?
the
They
there were
sold
no
4 of
takers.
them or
Yeah,
5
no
of them.
one wanted to
Not
buy
many.
it.
Right. Now, to me, that's. I think that's. They had to go into this knowing that was going to happen. I mean, I think everyone told them that was going to happen. I still wonder. I think the right question, but it's one we can never ask because of the way these things play out, would be: had Microsoft never been allowed to, bundle in this code and the plumbing to start with, had they always done things the way other applications developers did, then would there have been a lot of demand? We'll never know because the world was that they included it. But again, that sort of goes back to the piece of this case that's always fascinated me, which is where do we draw the line between what's kind of efficient, pro-consumer, pro-competitive evolution of a platform like an operating system? Because there's no question operating systems change, everybody's, not just Windows. Every operating system changes over time. More and more functionality gets put in, more things are integrated, more things work together. The last thing we want antitrust to do is get in the way of that. But at the same time, I think the case proved there comes a point where integrating things in or tying it or however you want to describe it can be anti-competitive. And I think the big gray zone that was never really resolved in this case, and maybe will be somewhere down the road, is both where and how we draw that line so we're as protective of innovation as possible, and yet we don't allow things that cross over into truly anti-competitive conduct. It's a tough thing to do.
And it may be that what consumers prefer would lead to a single provider.
Mm-hmm.
I mean, do people want to plug and play out of the box? They're not going to be there configuring their device.
Right.
It's going to come with something that appeals to the largest group.
Right. Although there are various ways to get there. I mean, one of the things DOJ said all along was, it's true. There were a few businesses that didn't want a browser on their computers because they didn't want people surfing the web at work. But for the most part, people didn't want a computer without a browser, without the ability to get to the internet. But you could imagine different ways of achieving that other than putting one into the operating system. You can imagine a requirement that says when you ship Windows you have to ship a browser. Doesn't have to be Internet Explorer. Gets messy and complicated and quickly inefficient, but there are other ways to think about it.
Yeah, let me just say, I do think that, maybe not surprisingly, that the sort of right balance was struck. I think it's hard for the government or the law to say that there is some point at which there is too much integration, there's too much added functionality to be worth, to be good for consumers. On the other hand, I think what the lesson of the case is that there are ways that it can be done that, to some extent you can have your cake and eat it too. And that was what the decree was designed to do, not get the government so much involved in design, allow Microsoft to control the design of its product, but to leave that product open so others, in effect, could have access to it. And I think those rules, in some ways I view Microsoft as being the case that said, and this is somebody who argued the other side of it for a time, it was a case that said that you could take existing pretty well settled antitrust principles and apply them to new technology industries that featured things like network effects and that sort of thing, and the world wouldn't come tumbling down, and actually maybe you could make the world better off. I will say that I think, though, having said that, sometimes some people like to interpret the Microsoft case as unique. That, and you sometimes hear the Microsoft exception, and that the case is really, somehow Microsoft was a unique company, and so we apply the rules to Microsoft, but we shouldn't apply them later on. I think from at least my perspective, I wouldn't say this is Microsoft's perspective, but from my perspective, it's important having established rules like that they get applied sort of even-handedly and in a way that is blind. And not surprisingly, people who today find themselves in a position of importance have reasons to say, well, gee, we're involved in developing something that's very complex, highly technological, and therefore the antitrust laws shouldn't affect us. But I think the lesson for Microsoft, and for antitrust rules to be effective, they kind of have to be applied uniformly, and Microsoft shouldn't be seen as kind of an exception, but it probably is the rule. But again, I think you can take some comfort from the fact that it wasn't a decision that said, well, we think this is too much integration or that's not enough integration, but instead, here are the rules. You can integrate, but you just have to do it according to rules that don't exclude other people from the marketplace.
So you think, Phil, that there is a rule coming out of the case that really has practical application going forward, and has it been applied?
Well, I think there are several. One is the one Rick mentioned, with which I agree wholeheartedly, which is, there's nothing, and this question comes up over and over again. Every 3 or 4 years we seem to have the need to do this. We had the Antitrust Modernization Commission study several years ago. We had Senate hearings a year or two ago. Asking the question, are the antitrust laws up to the task of dealing with the new economy? Can they deal with technology? My sense is the Microsoft case should have mostly settled that. I mean, I really do think it showed that particularly on the liability side, questions a little more on the remedy side, but certainly understanding industries and delineating between efficient pro-consumer conduct and anti-competitive exclusionary conduct is possible, even when you're talking about highly dynamic, fast-moving industries where things change and you have network effects and you have a lot of these special circumstances. I think that rule, to me, is very much set. And I do think, had the case turned out differently, we'd be in a very different position. I think we would continue to be fighting those battles, or maybe we would throw up our hands and say, oh, well, I guess it doesn't apply. So I think that rule certainly comes out. And I think, I think the test that you and your court used for trying to distinguish those is a good one. That's actually very valuable.
When you say that, you include the balancing test?
I do. I mean, that's obviously controversial. It was stated but not really done in the decision, so I think we don't know exactly what it means.
Well,
and
one
how
way
it
of
would
looking
work.
at it, and I actually didn't think of this until I saw Eleanor Fox suggested, not that she was endorsing it, but that it could be read to mean if there's any justification offered by the firm, any pro-competitive or consumer-oriented justification, then that tips the balance. That's it.
I mean, that I would prefer a rule that's a little more rigorous than that. That sounds a lot like.
Eleanor would too.
Right, and that sounds a lot like what the panel in Microsoft 2 said, which is if there's any plausible claim of efficiency, if there's any plausible claim that you're actually making things better, that's the end of the inquiry.
Well, but there the inquiry was intruding into product design.
Right. So it was especially skeptical. Right.
Although the thing that well, all right.
Okay.
Never.
Well, let's see if we've generated any questions or if it's all perfectly clear. Yeah.
Yeah, Phil alluded to what is probably the simplest critique of antitrust policy overall, which is we don't need it because the markets will take care of everything.
Can you hear that back there?
No.
Okay. Why don't you address yourself to the rest of them?
Sorry. Saying that Phil alluded to the simplest critique of antitrust policy, which is that we don't need it because the markets will care for everything. But there's a subtler critique that I tend to prefer, and that is that frequently when we find that people have been able to corrupt markets through anti-competitive behavior, it's because there was a failed government policy behind it. I've done a lot of work that looked at the role of the intellectual property treatment of software played in Microsoft's ability to affect the markets the way that it affected the market. And I wanted to know from the players on the inside whether any of that discussion had gone into thinking through both how to approach the trial and how to approach the remedy.
Well, the only thing, I don't know who to attribute it to on the court, but there is a famous statement in the decision, Microsoft 3. Have you got it? You gonna pull it up? Baseball bat. And I mean, Microsoft thought at the time that the case was litigated that it had a very strong argument, because basically what the government was saying is that it had violated the law by not allowing OEMs to remove access or to remove. There was a question about what exactly
Right.
we're arguing. Removing access to Internet Explorer. And Microsoft's point was, hey, look, if I wrote a 30-chapter book and I put it out there and somebody took chapter 16 and 17 and ripped it out, that and then tried to sell it, that's not the copyrighted work. I ought to have control over that. And this is the same thing. We made the operating system. We put Internet Explorer in it. We don't do anything to stop anybody, notwithstanding common wisdom to the contrary. We don't do anything to stop other people from putting other applications, including Netscape, on the operating system. We just say that you got to leave IE there and exposed. And the company argued that it had an absolute defense under the Copyright Act to do that, to make sure that the work that it created got to the consumer the way it had been created. And this is what the court said. You want to basically that you may have a right to a baseball bat, I think, but how you use that baseball bat could be relevant.
Doesn't mean that using your baseball bat cannot give rise to tort liability.
Right. And so again, there's the quote: intellectual property rights do not confer a privilege to violate the antitrust laws. So that was an issue that we thought that Microsoft at the time thought was a pretty important one. This is not an unsensible rule, though, to say, and frankly, this kind of view is the view, having been at the department in the 1980s when the treatment of intellectual property underwent a sea change in terms of getting more favorable treatment. There was always this view that simply because it was intellectual property, it was going too far to say that somehow it created an immunity. Rather, it's more appropriate to view it as a form of property, subject to all the sort of limitations that any form of property has. And that's really, I think, what that court was getting to there.
Yeah, the only thing I would add, one of my colleagues, Jonathan Zittrain, wrote an article right around the time of the remedy that he called the un-Microsoft un-remedy, in which he proposed, I think more as a thought experiment, the idea that a different way to fix the problem, rather than the remedy that everyone was thinking about, was to limit the term of copyright for software, at least for software operating systems, to 5 years instead of 1 million years as it is now. That because of the pace of change, because of how quickly everything moves, you would still create all the incentives to innovate that we want our copyright system to create, and yet with a 5-year lag time, others could come along, sort of build on it, do other things. I was never a big fan of that, but it's an interesting way of thinking about the interplay between, the power that copyright gives people in this space and what happens in the case.
It's not actually 1 million years now, it's 1,000,004.
Yeah, I'm sorry. Forgot about the Sonny Bono extension.
21 years plus
Back there.
I'm a very satisfied user of Firefox, but more often than not, when I open up a window in Firefox, immediately Internet Explorer inserts itself into the screen in a smaller version, as if to punish me for selecting the wrong browser. Is that something that the consent decree failed to address?
Have you considered getting the 2000 version?
I have the current version 7.
Oh, Rick, what's
I
going
can't
on?
answer the engineering questions. I'm sorry.
It doesn't happen on mine. I don't
Yeah,
know.
no, it doesn't.
Yeah, an example of something like that was in the case was certain instances where a user would choose Netscape or a different browser, and Microsoft Internet Explorer would still launch and create what one internal Microsoft document called a jarring experience for users. Judge Jackson found that was anti-competitive, that helped to exclude rival browsers, and the Court of Appeals said, no, that's actually one of these cases where there is a justification for doing it that way. That happens when you're trying to access the Windows Help system, or when you're doing Windows Live Update. Both of those, as a technical matter, require Internet Explorer. So we're going to reverse the finding that was anti-competitive conduct, because there the sort of back and forth balancing shows there is a good legitimate justification. There's a business reason to do that. I don't think that's what you're describing, but there was a bit of that in the case.
You might try to invoke the add remove utility and see if you can solve that problem.
Can you actually remove Internet Explorer?
Yeah, you actually that's why it's called the we refer to it as the SPAD. But,
yeah.
The set program. Program access and defaults.
Access default, sorry.
Yeah. And again, there was an argument because that was the only place in the opinion where defaults came up.
Mm-hmm.
The department took the position that it was in only those circumstances that Microsoft could decide the default, and we ultimately, that's the way the decree is written. But you could read the opinion as saying that Microsoft has the right to set defaults. I don't know exactly what your machine is experiencing, and it I think is inconsistent if you've set Firefox as your preferred browser. If you set it as the default and you've basically hidden access to IE, I'm a little surprised that your browser comes up that way, because I don't want to say it's not supposed to, because I don't know exactly what it's doing, but
Yes. A number of questions, but I'll just limit to one right now. Back during the day, during when Microsoft was in the headlines from day to day,
often there were devastating disclosures of emails, all right, as part of testimony. And one of the rules, at least as a business attorney, corporate law practice of the case is don't write dumbass emails, or say dumbass things in person, but don't put them on paper, don't make it discoverable, don't do any of that stuff. So the question is twofold.
Let me write that down.
For your next event.
Avoid
So it could explain why there's Microsoft attorneys at every meeting now to tell them how to do that. But the question is that that was the public perception. These emails were devastating to the case, Microsoft's position. From the department's position, recollection, were they really that significant? And if there is indeed a new kind of don't write things down rule, would it be almost impossible to try a Microsoft case or to push it to the same resolution?
Why don't you take the first shot?
Yes, I'll do my quick take on that. So we were certainly the beneficiaries of a lot of emails, and the case was one of the first that in a very visible way used email, though lots of cases before that had. And I think there are really two explanations. The main one is that's how Microsoft operated. Now again, you can tell people be really careful what you write down, do it in a careful way. But this was a culture where people were used to just communicating very quickly with their thoughts. There were very few really juicy, incriminating emails. Well, I don't know what Oracle's internal procedures are, but they were far more successful at avoiding writing down things that could be used, and maybe there just weren't any. But that was a case where you saw a very different set of emails to potentially use as evidence than you did in the Microsoft case.
Yeah, the point I would, again, can't speak to that matter, but I think that the difficulty is, one, you're dealing, for the most part, in these companies with non-lawyers. They're typically fairly young. They're getting older, as time goes by, but they're young folks who tend to communicate in writing, and that's increasingly true. Now, the mechanisms for communicating aren't just emails. They tend to be instant messages. They tend to be wiki, whatever they call them, wiki whatevers. And so there's a lot of communication still in among companies. And I don't care what you do, it's very hard to constrain engineers from speaking the way they speak. And I'll just give you an example of a different company, one of my favorites. You should look at, there's a suit that a company called Skyhook brought against Google. Some of you have heard of Google. And a number of the documents got released, and Steve Lohr at the New York Times did a story, I believe, yesterday. And he was kind of talking about how a lot of the mails and the information that got produced was very reminiscent of Microsoft. But in addition, there was one that he pointed out that Microsoft even never did, and it was an email where one of the guys said thread kill, basically that enough of this talking on the email. We've said too much already, so don't do any more emails. Call me offline, actually, is what the last line of the email said. So it's a problem that's going to be there because people are not going to go back to just talking. They're not going to go back to being careful in writing letters the way when we were young people thought about writing. The way people communicate today is in a tangible medium that is captured somewhere forever. Now, sometimes it's hard to find that, and part of what lawyers do is fight to keep anybody from finding it. But generally, it exists, and I don't think there's much you can do about it just because of the way everybody communicates who's half my age and younger. That's just the way they do it.
I'm very skeptical about the use of hot documents in these kinds of cases because they don't represent the considered legal position of the company, and you have people using a lot of metaphors and strong language, about crushing the competition and that sort of thing. It doesn't have any economic significance. Plaintiffs love to use them for intent evidence, I think. But even there, I think it's pretty thin. Notwithstanding what your advice is sound, no dumbass messy.
There's a rule coming out of the case.
Yeah, right. Right. I think we have time, maybe, Dave, for one more?
Oh, yeah, yeah,
Okay.
one, two more.
Okay.
You know, more if you wish.
Is there any question left unanswered?
I have a question. What were the companies that were strongly behind the government's efforts in the late 90s and the era of the consent decree, and how have they either taken advantage of the terms of the consent decree, or how were their hopes of improving their position not realized?
Yeah, that's a great question. And again, without disclosing confidences of people that came to us, I think certainly a lot of, so Netscape was obviously the primary first complainant, and in a natural position to be complaining, and we know what happened to them because things didn't move fast enough. A lot of Microsoft's server competitors were very much concerned about the communications protocol issues, and certainly pushed hard for that. And I would leave it to Rick, because I've been gone from it for far too long, to say whether or not the way the communications protocol 3E part of this decree made any difference at all for any of them and what they do. Now, they also, I think, formally lobbied the European Commission much more and got more there in terms of server-to-server interoperability. But again, I don't know. I think it's a great question. It would be a great study to see what did they get out of all of this. I think Rick alluded to the fact, and I know this only third hand because I was gone by this time, but Google lodging some complaints along the way during the consent decree enforcement process. One of other people who lodged it. Again, you have to try to figure out, was there any causal connection between that and what actually happened. You now have Microsoft filing a complaint against Google in the European Commission. And so the sort of circle is coming around. I think it's a great question. And the one thing I would say quickly is the DOJ got a lot of criticism during the early part of the Microsoft case and even the trial for essentially allowing rent-seeking by competitors, allowing competitors to come in and use the courts, use the department, use the enforcement process to gain a competitive advantage. And I can tell you we were incredibly sensitive to that. Because it's a huge problem, and I think you have to be careful, whether it's Microsoft complaining about Google, whether it's Google complaining about Microsoft, whether it's Netscape complaining about Microsoft. I think the Justice Department, at least, I won't speak for others, DOJ is pretty good at taking those kinds of things with a few pounds of salt, not just a grain, and really analyzing and investigating carefully. But it's a feature of investigations in this area that seems not to go away.
And I think inevitably and historically, the way the department is going to learn of most kinds of exclusionary conduct is by the companies that feel that they've been excluded.
Right.
And then the question is, well, okay, what's the reason? Was it a violation of law? So, that's always going to happen. With respect to people taking advantage of it, there are supposed different views, but just a few statistics. Because of developments on both sides of the Atlantic, at the end of the day, the only thing that was getting licensed are patents, and so the protocols and the documentation itself is actually available. You can go get it today. And there have been, I think, at last count, over 500,000 downloads of the documentation, the communications protocols documentation. If you want protection for some of the patents that are incorporated or that are incorporated by the protocols, you can get those licenses really at a fairly nominal sum from Microsoft. And I've forgotten what the number, I think it's like 20 or 30 licensed products are out there, so people are actually using the protocols. But because there are 500,000 and you don't actually have to have a license if you think you're not infringing Microsoft's patents, or you have a cross license otherwise for Microsoft, it may be that the number of companies that are actually shipping products that are using those communication protocols is much larger.
you want to see those protocols, just go to download insomnia.
A follow-up question on the what's been instrumental in the evolution of technology, and can it be argued that things like the vast increase in the speed of the internet in the last 10 to 15 years, the vast increases, especially per dollar, of storage capacity. So 10, 12 years ago, your programs came on disks or were preloaded on your hard drive that was tiny compared to the terabytes available to you now. And then the speed with which you can sort of plug in a program, and then other models of programs like apps on your mobile devices. Were these changes ones that would have pushed Microsoft to a less dominant place, or were those things, did the combination of those developments and other things and the consent decree make the way for the world we see today?
So a couple of quick things. One, I mean, those are exactly the kinds of highly dynamic, fast-moving changes that go on in industries like this that make this whole thing so difficult, and that enforcers and courts struggle to try to understand and figure out and know that they're not going to be able to predict very far down the road. I would go back to my earlier answer and say that I think having the breathing room, having the opportunity for freedom from, Microsoft's attempts to exclude people's ability to take advantage of those things certainly has helped. But there's no question those things have made a different world. But I also think that it's really important to keep in mind that most of those things were things Microsoft was talking about at the trial as reasons why, first, the court should find they didn't have a monopoly. So they said, how can we have a monopoly? I mean, we could be swept away at any moment. Look, the world is changing, broadband is coming, people are going to be able to download applications, they're going to be, mobile devices, and so, don't worry. And that was sort of true in a way, but here we are now, 13 years from the trial, 15 years from the beginning of the investigation. It's just, the last couple of years, it's really begun. A lot of this has really begun in earnest. And so I think we need to be careful. I worry when people say the lesson is stay out of the way, the market will take care of it. Because these things take much longer than we would like to see a situation of anti-competitive behavior or stifling of competition go on. But we also have to remember these things happen. And I think antitrust has gotten pretty good at not doing what it used to do, of taking a static snapshot of the world today and saying, aha, look. I think we now really get it, that you've got to look down the road and you have to understand the innovative, dynamic nature. And if antitrust doesn't do that, then it runs a huge risk of making mistakes and trying to fix a world that's going to disappear in the next 2 or 3 years anyway.
The tendency, though, Philip, the consequence, I guess, of taking a dynamic view means fewer cases.
Right.
With maybe an exception for some sort of predation where you envision a stage 2 where there's recoupment. Right. But ordinarily that means a less intrusive or less vigorous policy.
I think that's right, although one thing that your decision, the Microsoft 3 decision pointed out very well was we don't need certainty. There's going to be some uncertainty, and in this case, Netscape was a nascent competitor. I mean, it was still very new. Nobody knew how it would have turned out. And what the court said was we can't let that uncertainty alone be a reason not to find liability if the plausible story is there. Otherwise, competitors, incumbents could always kill off new rivals and say, oh, well, we don't know, they might never have turned into anything. So I think you're right. I think it does mean less cases, more carefully chosen and very carefully developed
Although
cases.
the one thing I would say is I think that there were some of us at the time in the 90s who thought that it would be rare that you'd have a case that involved software or something like that constituting a monopoly or sufficient market power to be worthy of concern. And the one thing that I think is true is that there does tend to be some duration to the position of being the lead frog. Frogs beforehand, the dominant frog or whatever, and you can be leaped, but the fact is that they tend to be fairly durable, and whereas maybe 25 years ago, you always conceived of monopolies as some kind of physical facilities that were in the ground and that were hard to duplicate. The fact is, I think we know a fair degree more to understand that notwithstanding these dynamic principles, you still can find yourself in a position where you do have market power and where the law, Section 2, imposes certain obligations on you because of that power.
What a statesman.
I learned it from the best.
I think we have time for one more. And
Just
then
say, in reference to what Rick just said, though, that all of the firms that are leaders in these fields, whether it's HP or Microsoft, they were all garage bands.
At
20
one
years
time,
ago.
yes.
Yeah.
Yeah, it was. But sometimes you got to grow
And
up.
we don't know
you
who's
gotta grow
out.
up.
You don't know who's out there now.
Sure, absolutely. And there will be another one, and at someday they may be lucky enough to be worried about Section 2.
But we won't be around.
Well, we won't be.
You'll be there waiting for them.
David, were you?
I think we can see one more question. Alan?
Sure.
This question for Rick. Rick, an opportunity maybe to brag about your client. If Microsoft has now become a model corporate citizen, what combination of leadership at the top or middle management or organizational culture or something else would you attribute that to?
Well, I mean, I do think the decree made a difference. And I will say, not because I'm trying to suck up to anybody, but but I do think that there is that part of it had to do. It's hard to not attribute part of it to Steve Ballmer and Brad Smith. I mean, Bill Newcomb and Bill Gates were important, very good people. I think who sometimes took a bad rap. But when Steve and Brad took their respective roles as CEO and General Counsel, they really did spend a lot of time devoting themselves to, in effect, transforming the company to reflect what the decree was requiring them to do and what the company felt was its obligation. So I think the decree was there. I think it's also, I would be remiss if I didn't mention Bob Muglia, who actually ended up, I think the judge found him to be very helpful at one point during the process in coming in and sort of taking over the documentation process. So even though Steve and Brad were important leaders, I think it's fair to say that the message, has gotten through to a lot of folks in the company, and a lot of them are responsible for what's happened with the company.
You realize that Bill Newcomb has done well since then?
He probably had a lot more fun than the rest of them, that's for sure.
When do I get my baseball team?
Well, I want to thank you all for coming this evening. Before I thank the panel, we always note the presence of our local bench, or in this case, former local bench. So I want to welcome and thank for coming Judge Walker. It's great to see you, and you've always been a great supporter of this chapter, and you have a lot of supporters in this chapter. So thank you for coming. And I also want to thank our panelists, Judge Ginsburg, Rick Rule, Phil Malone. Thank you for bringing us your insights into the Microsoft consent decree, and we'll see what happens 10 years. We'll have you back in 10 years.
Okay, great.
Perfect.